sorry.
Okay, this is Holder versus Hacker King Sherry Agency consolidated with Pioneer State Mutual Insurance Company versus Holder. We're going under, because these are consolidated, we're going under docket number 17-768CK. And this is the time set for hearing on Pioneer State Mutual Insurance Company's motion for summary disposition. And now I'll take your appearances for the record, please.
Good afternoon, Your Honor.
Good afternoon, Your Honor.
I'm on behalf of Todd and Sharon Holder.
Good afternoon, Your Honor. Greg Nave on behalf of Pioneer State Mutual Insurance Company.
Good afternoon, Your Honor. Frank Fleischman on behalf of Hacker King Sherry.
Go ahead, Mr. Nave, whenever you're ready.
Thank you, Your Honor. Your Honor, I'm sure that you've read all of the briefs and you've read the prior briefs and the cross motions, so I'm going to get right to the key points. This is a case where, based on everything that's been submitted to the court, there are no genuine issues of material fact concerning the representations that were made to Pioneer on behalf of the holders. Two key issues. One, the representation was made that Brittany, their daughter, was the primary driver of the subject 1999 Chevrolet box truck. And secondly, and probably more importantly, the representation was made that this was not being used as a commercial vehicle. Along the way, those misrepresentations were never corrected. With each renewal of the policy, the holders had an opportunity to make a correction. They never did. So what is clear is that this is a personal automobile policy, and Mr. Holder was the exclusive driver using it exclusively in his business. The issue that has been before the court before, and I think is pointed out very succinctly by counsel for defendant Hacker, is that there is a dispute between the holders and defendant Hacker as to who said what. That is not relevant. It's not material to the issue before the court today. The issue before the court today relates to what were the representations made to Pioneer. It's very clear, the law is clear, that the hackers, or that defendant Hacker was an agent for the holders. They're an independent agent. They're not an agent of Pioneer. So regardless, whether it was Mrs. Hacker, who was the source of the misrepresentation, or whether it was some omission or mistake on the part of defendant Hacker, the fact remains that the misrepresentation was made to Pioneer. Based on those grounds, or on that undisputed fact, Pioneer is entitled under the policy to rescission. And in terms of whether or not that would have been, the policy would have been rescinded or issued initially, it's also undisputed, and we submitted the testimony of William Comstock indicating that this policy would have never issued under these circumstances. It's a personal auto policy. It's not a commercial policy. Counsel for plaintiff, or counsel for the holders, has raised some issues under BASI. And as Your Honor may recall, this is a renewal of our motion. Prior to BASI, we went up to this point in the proceedings as it relates to our motion for summary disposition. And at the hearing, Your Honor had indicated that you were going to grant our motion. But because of the pendency of BASI, that was put off. BASI does not apply in this situation. Mr. Holder is a party to the insurance contract. He is not a third party to the contract, and BASI addresses the issue that arises when you have an innocent third party. Mr. Holder is not a third party. It's also our contention that he's not innocent. because along the way, he made representations to his own commercial insurer. In the prior motions for summary disposition, we saw Spalding arguing to your court or to the court that, in fact, Mr. Holder had indicated that everything was good. He didn't need commercial coverage for this vehicle. And that's been undisputed. But what happened after that, in terms of what Mr. Holder did, he never took any opportunity to correct the mistake. And even if we were to engage in the Bozzi analysis and look at those 5 factors that Justice Markman has set forth in the Farm Bureau concurring opinion, that's kind of forming the basis for analysis of whether or not an innocent third party whether or not a policy should be rescinded as to an innocent third party. What's clear in examining those factors is that Pioneer is an innocent third party. They had no information, no reason to disbelieve the holders that this vehicle was being driven by Brittany, that this vehicle was being used for personal use. So even if we were to engage in that type of a weighing of the equities, we would be looking at things such as, did Pioneer have an opportunity to do things? And there's no evidence that they did. Were the holders somehow participants in this misrepresentation? And the answer would be yes. Is there an alternative in terms of recovery? And based on the fact that the holders have sued their own agent because of their claim that it was defendant Hacker that made the misrepresentation, there is an alternative avenue to recovery. So if we look at all those factors, even if we were to apply them, the equities would weigh in favor of rescission. So based on all of these undisputed facts and the clear law, we believe that summary disposition is appropriate as to Pioneer.
Thank you. Mr. Komar?
Thank you, Your Honor. First, I'd like to address the comment that there's no genuine issue of material fact. As the court will probably recall, I think we were there and it was late February, maybe late January, I can't remember. But Holder filed a motion against Hacker King Sherry with regard to the element of negligence. Hacker King Sherry filed a cross motion with regard to the whole idea of fraud. And the court in that claim said that there were questions of fact regarding the nature and the extent of the conversation between Ms. Holder, Sharon Holder, who was the one who contacted the insurance agent. And there was a dispute the court said that the jury still had the ability to weigh her credibility. So still there is a question of fact concerning what happened with regard to the conversation between Ms. Holder and Ms. Smith, who was the agent at Hacker King Sherry. And I rehash that because that conversation goes to the very heart of Bozzi. In this particular situation, Ms. Holder made it very clear that it was the agent's idea. And again, this was all decided on a question of fact in the previous motions for summary disposition. Ms. Holder made it very clear that it was suggested and brought up by the agent that we will make Brittany the primary driver on this vehicle. And Ms. Holder didn't question it because she testified, she's the agent, we thought she knew what she was doing. And this is further supported by, Charles Sherry, who is the president of defendant Hacker King Sherry, and he specifically testified on page 31 and 32 of his deposition. He said certain rules will allow us to list the most youthful driver on the least expensive vehicle. And he mentioned Pioneer as being one of those vehicles. So how can Ms. Holder or Mr. Holder be accused of fraud when they're being told by an agent that these are Pioneer's rules that they can follow? And further, a big portion of what was brought up during the cross motions for summary disposition between the Holders and Hacker King Sherry was the fact that Ms. Holder specifically said, and I'm paraphrasing here, Todd got a new work truck. We need to put insurance on it. And the big issue there was Charles Sherry testified that the instant that Ms. Holder uses the term work truck, everybody's got to call a timeout with what's going on. And we got to send this over to a commercial lines agent to make sure that we get this right. So that conversation, which took place between Ms. Holder and the people at Hacker King Sherry, go to the very heart of BASI. It goes to the very elements of BASI because Mr. Holder is specifically relying upon an agent, and more critically, and defense counsel brought up the idea that Mr. Holder never went to Pioneer to correct anything. Well, Larry Limenoff, who is the underwriter for Pioneer, specifically stated, our insureds can't contact us. They cannot pick up the phone and call us and tell us that something is wrong. They can't email us anything with regard to their policy. They can't fax anything in. They have to go through the agent. So the holders believe that they have all of their coverage in line. This goes to the very heart of BASI. Now, Mr. Holder is, yes, he is a party to the contract, but he's going to an agent that Pioneer says you have to use. You can't come to us. So he's relying upon information that he's getting from the agent. And again, this was all decided. These were questions of fact that the court had already ruled on between Holder and Hacker King Sherry. So in this instance, Pioneer can't point the finger at Mr. Holder and say, well, this is fraud, when Mr. Holder thinks he's doing everything properly, when he's going to somebody who's licensed to do these things, when he's getting information from this agent saying, yeah, we can do this, and here's how it's done. So this is not a situation where Mr. Holder went online, like I'm seeing far too often with Esurance or with Progressive, or where you can go online and add your own vehicle and change your own vehicle and all that stuff. Pioneer specifically says you have to go through an agent. So how can Pioneer then turn around and say Mr. Holder committed fraud when there's these gigantic questions of fact concerning who said what between Mr. Holder and the actual agent itself? And the agent specifically said, and the agent specifically testified, according to Pioneer, this is okay. This is absolutely okay to do this. So that goes to the very heart of BASI. With regard to, I'd like to then shift gears and go away from BASI, because I know the court has probably read that 3 or 4 times and is tired of it. But the new decision of Pioneer versus Harris is published, and that's from February 11, 2020. And that's a Court of Appeals decision, which is citing Justice Markman's concurring opinion in Farm Bureau versus Ace American Insurance, and that's 503 Mesh 903. And the first factor to consider when rescinding a policy is the extent to which the insurer could have uncovered the subject matter of the fraud before the innocent party was injured. Now, the holders are not conceding that fraud occurred here. But even if you want to say, yeah, there was some fraud here on behalf of the plaintiff will say it's on, the holders will say it's on behalf of the agent. But the extent to which it could be uncovered is easy. It's a phone call. And whenever I have used one insurance carrier, Judge, my whole life, I go through an agent. And the last time I added a vehicle was 2 years ago. And I went through an agent. And every time I add a vehicle, I get a phone call from Citizens. And Citizens wants to know the who, the what, the why, the where, and the how. It's a 4-minute conversation. And they always ask me, are you the owner of the vehicle? Is anybody else the owner of the vehicle? Where are you going to be driving the vehicle? Are you going to be using the vehicle for transporting other people? Are you using it as part of the work? All of those questions that they go through. It's 3 minutes. And that's it. So with regard to the first factor set forth in Pioneer versus Harris, this is something that if anybody's doing their due diligence at Pioneer, this is something that's very easily uncovered. Under factor number 2, and again, I'm looking at a different computer screen, Your Honor, so forgive me for not looking at the camera. With regard to factor number 2, the relationship between the fraudulent insured and the innocent third party to determine if the third party has some knowledge of the fraud. In this particular case, and I don't want to beat a dead horse, but what I've talked about is there's a relationship between Mr. Holder and Hacker King Sherry. And I've discussed that testimony over and over again. And I don't think that under factor number 2, under Pioneer versus Harris, I don't think that Pioneer's motion should be granted, because Mr. Holder is relying upon information that he's getting from the agent, relying upon the actions of the agent. Under factor number 3, the nature of the innocent party's conduct, whether reckless or negligent in the injury producing event. This is not a third party claim. This is a PIP claim. I don't think that factor applies. I think that has to do with the liability coverage. Under number 4, the availability of an alternate avenue for recovery of this policy is not enforced. Yes, there is, in fact, this other case that's going on against Hacker King Sherry. But in that case, it's different, and the burden of proof is different. In that case, it's a negligence claim. So I have to show against Hacker King Sherry at trial that the agent had a duty, breached that duty, and caused injury. That is a completely different standard than under the No Fault Act, where I have a burden to show that there was accidental injury through a motor vehicle accident and my client incurred expenses. That's an apples to orange sort of argument. And as I read Justice Markman's factors that he sets forth, I believe that the availability of an alternate avenue of recovery, I think what he's generally referring to is, all right, is there a health insurance carrier on board? Is Blue Cross and Blue Shield? Is there Cigna? Is there Medicaid? Is there some other avenue in which the plaintiff can get these expenses taken care of? With Mr. Holder, there was no health insurance. He did not have health insurance at the time. This is his only avenue of recovery for this motor vehicle accident. Because there are different standards between the No Fault Act and a negligence claim, I don't believe that the two avenues are equal. Under number 5, whether enforcement of the policy only serves, again, I'm reading from Justice Markman's 5 factors, whether enforcement of the policy only serves to relieve the fraudulent insured of what would be the fraudulent insured's personal liability to the innocent third party. I don't believe that that factor applies because, again, this is a no-fault claim rather than a tort claim. I know that I have briefed this thing to death, Your Honor, and you have read motion after motion on this, and you've read pages and pages of deposition testimony, Your Honor. But if there was ever a case where BASI should apply, I think it should be this one, where you have an interaction between an agent and the insured. This is not a situation where Mr. Holder is specifically going directly to Pioneer and doing these things himself. I don't have any further comments at this time, Your Honor, because I know you've read this stuff forward and backwards multiple times.
Thank you. Mr. Fleischman, you filed a written reply. Did you want to be heard?
Your Honor, I have nothing to add to but our written reply.
All right, thank you. Then Mr. Nave, rebuttal.
Just briefly, Your Honor. Addressing the BASI issue first, I think that as counsel went through those 5 factors, what was clear with respect to each one was the reference to innocent third party. Mr. Holder is not a third party. He is a named insured. With respect to some of the other issues as far as the whether there's a dispute as to any material fact, the hacker firm is Mr. Holder's agent, not Pioneer's. That is clear. That's a matter of law. They're an independent agent. They represent Mr. Hacker. A dispute between a principal and their agent, there's no basis for that then resulting in a denial of a remedy to Pioneer in this case. That's the dispute as to whether or not the agent did what the principal asked them to do. It's still undisputed, and counsel has pointed to no fact which would show that somehow a different representation was made to Pioneer. Counsel cited the Pioneer versus Wright decision. And with respect to that decision, the issue there was whether or not Pioneer had unduly delayed in bringing a DEC action, whether or not they exercised due diligence. There is no assertion here that Pioneer delayed. And with respect to the due diligence, we're back once again to whether or not Pioneer has a duty to investigate as to whether all of the independent agents out there properly represented their insureds when they reported to Pioneer. What is clear under rescission law is that this is a case where the misrepresentation concerning the driver and, more importantly, the use, which counsel has not addressed, the commercial use of this vehicle, whether or not Pioneer is entitled to then rescind this personal automobile policy based upon the fact that Mr. Holder was the exclusive driver and used this vehicle exclusively in his business. Based on all of these factors, we believe that summary disposition is appropriate. Thank you.
Thank you. Well, first of all, there is an issue of fact in this case, as counsel has noted. I've previously ruled on this. I think at this point we can safely say that the information that Pioneer had was not correct. They believed that the policy was covering a vehicle used for personal use and that the primary driver was Brittany, the Holder's daughter. But that's because of the conversation that took place when Mrs. Holder called Hacker King Sherry Agency and spoke to Ms. Smith in order to add the truck onto the policy. And that's where the issue of fact arises. Who is responsible for the misinformation that went to Pioneer? Is it the Holders or is it Hacker King Sherry? And that came out in the Holders motion for summary disposition, where, just to recap briefly, Sharon, I'm not sure I always say her, Mrs. Holder said that she remembered saying that Todd got a new work truck, and she also said that she never asked for Brittany to be the primary driver on the vehicle. She said that Mrs. Smith suggested it. Mrs. Smith, on the other hand, had no recall, independent recall of the conversation, but there were two factors that created a conflict or raised an issue of fact. One was that the policy of the Hacker King Sherry was that had she said Todd got a new work truck and had she understood that this was to be used in work commercially, that it would have immediately triggered going to a commercial agent in order to obtain the policy. And then also, there was not a note in the activity file so I'm missing the absence of evidence. There was not a note reflecting that in the activity notes. And then finally, there was a note that said, quote, daughter PO, I think that's primary operator, per Mrs. Holder. So, that's what created the conflict and the issue of fact. And that is still true today. But Pioneer takes it the next step and says that even if the Holders, who are Mr. and Mrs. Holder, are the named insureds, even if they're not responsible for misrepresenting the facts, then Hacker Sherry King is, and And the argument is that it doesn't make a difference. And here's what that's based on, and this is something the court is well familiar with, but it is pivotal in this case, and that is that Hacker King Sherry, and therefore Ms. Smith, is an independent agent. And as an independent agent, Hacker King Sherry is an agent for the holders. She's not an agent of Pioneer. And that's well illustrated, and I've ruled on this as well. Hacker King Sherry actually has a duty to the holders in conjunction with being an independent agent and being their agent. Therefore, the plaintiff, Pioneer, says, even if the holders aren't responsible for the false statements, Hacker King Sherry and Ms. Smith, being their agent, is. And so while the issue of fact is it's either one, we don't know which one yet because that has to be resolved. Pioneer's argument is that it doesn't matter. And I agree with that. It does not matter. So the issue of fact that was evident in the holder's motion for summary disposition is not necessarily dispositive here because of the pivotal fact that Hacker King Sherry is an independent agent and an agent of the holders. So that and in fact, Hacker King Sherry actually obtained the policy from Pioneer on behalf of the holders. So that takes me anyway to the policy language, which I think is also pertinent. The policy language in this case provides the entire policy will be void if, in obtaining or maintaining this policy, whether before or I think it's supposed to say after, there's a misprint in mine, after a loss, you, an insured, a family member, or any other person seeking coverage has, one, intentionally concealed or misrepresented any material fact or circumstance, two, engaged in fraudulent conduct, or three, made false statements. So this policy was originally obtained in 2006. The truck was added in 2011, and then Mr. Holder's very serious accident happened in 2016. Nobody's saying that any false statement was made in 2006, but it's undeniable and undisputable that in 2011, when the truck was added, regardless of who is responsible for it, for the incorrect information, it was at that time to be used in Todd Holder's business, and Brittany was not going to be the principal operator of the vehicle. It's also indisputable that after the policy originally was obtained in 2006, they had renewals. And even after the truck was added in 2011, they continue to have renewals from 2011 to the accident in 2016, and that the holders received renewals and declarations pages every year when it renewed, and they didn't correct the information that was false. And the information that appeared was that Brittany was a principal driver of this vehicle. Now, I don't think it's of consequence legally that they couldn't contact Pioneer via email or phone call. The fact remains that when the renewals and the new declarations pages came through, it had the misinformation in there. The holders received that and they did not correct it. So I think it's therefore indisputable that when the policy was obtained or maintained and insured, a family member or any other person seeking coverage made false statements, whether that was Mrs. Holder who handled the transaction where the truck was added, or Mr. Holder who received the renewals and declarations each year, including after the truck was added, or Ms. Smith with Hacker King Sherry, who acted as the holder's agent and obtained the coverage from Pioneer for them. And that analysis, I believe, holds true regardless of whether we're going under the policy language or the common law elements of fraud that the holders rely on. So the defendant's argument, or I'm sorry, the holder's argument that Todd Holder never made any statements to Pioneer really doesn't hold, where either his co-insured spouse did or his agent, Hacker King Sherry, did, and where at the very least he suppressed the truth when the yearly renewals and declarations arrived with false information as to the driver of the vehicle. Furthermore, and the holders argue this as well, the information as to the driver of the vehicle and the use of the vehicle in a commercial aspect is material. Materiality can be shown by the insurer's statement that it would not have issued the policy if it had known of the correct information. And that comes from a published case in 1995, Lash, L-A-S-H versus Allstate Insurance Company, 210 Mich. App 98. Pioneer's PIP and claim liability manager, William Comstock, testified that the policy would not have been written if the true facts were known. And that's hardly a leap in logic to conclude that he would say that, because they wrote a personal policy with the daughter as the primary operator, when in fact it should have been a commercial policy, and the daughter was not actually an operator at all, as I understand it, or certainly wasn't the primary operator. So from all of that, we can conclude that misrepresentations were made to Pioneer. The question, though, is can Pioneer rescind the policy? And that takes us to the next step in the analysis, and that is to determine whether Todd Holder, who suffered serious injuries, is an innocent third party in this setting. And that's because even though the innocent third party rule by itself is gone, Bozzi versus Sentinel Insurance Company says as follows: when a plaintiff is seeking rescission, the trial court must balance the equities to determine whether the plaintiff is entitled to the relief he or she seeks. Accordingly, courts are not required to grant rescission in all cases. For example, rescission should not be granted in cases where the result thus obtained would be unjust or inequitable, or where the circumstances of the challenged transaction make rescission infeasible. Moreover, when two equally innocent parties are affected, the court is required, in the exercise of its equitable powers, to determine which blameless party should assume the loss. Where one of two innocent parties must suffer by the wrongful act of another, that one must suffer the loss through whose act or neglect such third party was enabled to commit the wrong. So that's the quote from Bozzi, and that's why I think we still have to assess, and the parties have briefed this and argued it, as to whether Todd Holder is in fact an innocent third party. The holders say that he is an innocent third party, and they rely on Darnell, D-A-R-N-E-L-L, versus auto owners. However, Darnell was abrogated by the Bozzi case in 2018. So the plaintiff, I shouldn't say the plaintiff because these are consolidated cases and it's confusing. The holders have no other authority for the proposition that a named insured who misrepresented facts either directly or through his agent is an innocent third party. And I would add, it's really not possible for Todd Holder to be an innocent third party, because at the very least, He allowed the policy to renew year after year without changing or correcting the incorrect information as to the driver and the use of the vehicle. Therefore, I agree with Pioneer that the balancing of the equities to determine the blameless, which of the blameless parties should assume the loss is just simply not applicable here, because we cannot conclude that Todd Holder is an innocent third party. He's neither. I'll echo the words of Mr. Nave, and because it is correct in this case, unfortunately based on the facts and the law, that he is neither a third party, he's a named insured, and nor is he innocent in that, at least going by the plaintiff's common law analysis of the various different types of fraud, there's at least a silent fraud there, and also under the terms of the policy, misrepresentation of facts, that is either his co-insured's misrepresentation or his agent, Hacker King Sherry's misrepresentation imputed to him. And so for those reasons, I must grant Pioneer's motion for summary disposition. Mr. Nave, do you want to submit an order under the 7-day?
Yes, Your Honor. I will submit an order just based on Your Honor's statements on the record.
For the reasons stated on the record. Thank you.
Thank you.
That'll conclude our hearing.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor.